My name is Lorena McElwain, and I am the co-founder of SmartFeds Law Group. In this video, you will learn the three elements of an EEO claim. In order for your claim to be accepted, investigated, and adjudicated, it must state an issue, a basis, and a discrimination theory. Let's get started with the issue. The issue is the bad thing that happened. Examples of common issues include not being selected for a promotion, being denied training, receiving a lower rating, or being denied a request for reasonable accommodation. A claim may have multiple issues. With the exception of a proposed termination, an issue must be actual. For example, the claim cannot be the supervisor threatened to lower my rating. The claim has to be an actual, my supervisor lowered my rating. EEO does not investigate hypotheticals. The second element is the basis. There are 10 bases covered under EEO laws. They are race, sex, color, religion, national origin, disability, age, genetic information, pregnancy, and reprisal. If your basis is something else, it is not a basis that falls under the purview of the Equal Employment Opportunity Commission, but it could fall under another administrative process. Check out our video on selecting a venue. We are not breaking down the definitions of each basis in this video, but I wanted to bring a few things to your attention. Sex includes male, female, pregnancy, and LGBTQ+. Disability includes mental and physical conditions that impair major life activities. Religion refers to a belief system and need not be a mainstream religion. Age protects persons 40 years and older. Reprisal requires prior protected activity. Check out our videos on each basis to learn more about that basis. The third element of a claim is the discrimination theory. There are 5 theories of discrimination in employment. The first is the one we are most familiar with, disparate treatment, that is, treating someone differently from others. A disparate treatment claim might sound something like this. Whether the agency treated complainant differently when complainant was not selected for a promotion on the basis of sex, female. The second theory of discrimination is adverse impact. Unlike disparate treatment, adverse impact does not require intent. We see adverse impact in the context of class action suits, where the claim is not an individual, I did not get selected for a promotion because I am a woman, but rather a group claim, women don't get promoted because of an organizational policy, procedure, or practice. The third theory of discrimination is failure to accommodate. We have to be careful with this one because complainants often want to claim the agency accommodated their coworker but did not accommodate them, and this is faulty. Failure to accommodate is an individual claim. A third party will determine whether the agency made the appropriate decision based on the medical condition, the impact of the condition on the employee, and the employee's duties. Whether other employees are accommodated or not is not relevant to your specific condition, your duties, and how your condition impacts your daily life activities or duties. Failure to accommodate applies to both disability and religion. Under religious accommodation, for example, an employee may request an exception to a policy prohibiting hats in the workplace based on a religious requirement to have the head covered. Another example is an employee requesting accommodation in the scheduling flexibility to participate in religious services. These flexibilities may include leave without pay, using annual leave, adjusting the tour of duty, or swapping shifts with another employee. The fourth theory of discrimination is harassment. Harassment can be sexual or non-sexual. Both types of harassment may include physical harassment, such as touching or hitting, verbal, such as jokes, environmental factors, such as posters or pictures. What matters is not the intent of the harasser, but how the actions were interpreted by the victim. Sexual harassment is any unwelcome verbal, physical, or environmental conduct of a sexual nature that interferes with work performance and/or creates a hostile work environment. It can also involve quid pro quo, this for that as a condition of employment. For example, a supervisor promising a promotion in exchange for sexual favors. Agencies should have programs that are victim-centered to support victims of sexual harassment in addition to the administrative grievance process. Many agencies, for instance, have employee assistance programs that can provide trauma counseling and other resources to victims. The fifth area of discrimination is reprisal retaliation. This type of discrimination protects individuals who have engaged in prior protected activity or have voiced opposition to discrimination. Examples of protected activity are filing a complaint regardless of the validity or disposition of the complaint, serving as a witness in a complaint, requesting reasonable accommodation regardless of whether the accommodation was granted, or being associated with a complainant. Common examples of behaviors that could be interpreted as reprisal after engaging in protected activity include removing the employee from projects, denying leave, or lowering a performance rating if there is no apparent cause for the adverse action. As with issues and bases, a claim can have more than one discrimination theory. A simple claim sounds something like this: whether the agency failed to accommodate complainant when the agency denied a modified work schedule based on the complainant's disability, mental. When a claim involves multiple issues, bases, or theories, each theory, issue, and basis will trigger a separate test. For this reason, it is possible to prevail under one basis, issue, or theory and not under another. This is an important concept to keep in mind, especially if a reprisal claim is added to the original complaint. Let's say the complainant in the scenario we just discussed applies for a promotion, was not selected, and the agency cannot articulate a valid business reason why the complainant was not selected. It is possible for a third party to find the agency did not discriminate when it failed to accommodate the complainant. However, the agency discriminated against complainant when the agency denied a promotion based on prior protected activity, in this case, filing an EEO complaint and requesting reasonable accommodation. Most findings of discrimination do not result from an initial claim. Most employers lose cases because supervisors retaliated against someone who engaged in protected activity or voiced opposition to discrimination. It is important to allow persons to exercise their rights without fear of reprisal or retaliation. Smart Feds can help agencies with compliance training following a finding of discrimination, including executive coaching for responsible management officials. We offer our signature EEO Smarts coaching to employees, supervisors, and union stewards on how to engage in the complaint or grievance process, understanding which options or resources may be available to you, whether you should hire an attorney, responding to affidavits, and witness preparation to testify before a third party. Visit our website, smartfeds.net, to schedule a consultation or to sign up for our monthly webinar, where you can ask us questions and hear what's buzzing in the world of EEO. If you found this information useful, subscribe to our channel, like this video, and share it with others. Stay smart, stay strong.